We'll hear argument first this morning in Case 13-7451, Yates versus United States. Mr. Badalamenti.
Justice Ginsburg, in Section 1519, it was passed at the same time as 1512C as part of the Sarbanes-Oxley Act. And as this Court held in Rossello, when Congress includes different terms in different statutes passed in the same act, it is intended to mean something different.
So you think there's a difference between tangible object and other object?
Yes, there is. The first reason is that the inclusion of makes false entry in indicates that the phrase record, document, and tangible objects refers to record keeping. Another difference is that a common sense standpoint is that records can only be maintained on tangible mediums. And it's a distinguishing factor between record, document, and other objects in 1512C. It's also a limited.
How is the Internet? You can falsify Internet entries.
Would not be the piece of paper that the typewriter is inscribing on is a device that's designed to preserve information. It's simply making the information.
I understand the argument, and the argument that you make has considerable force about over-criminalizing. But it seems to me that the test you suggest has almost more problems with vagueness, more problems with determining what its boundaries are than the government's test. Suppose a typewriter were used to prepare an incriminating document and the typewriter were destroyed. Would that be covered?
No, the government's test renders 1512C wholly superfluous. The very matters involved in the Enron debacle. Given the expansive federal nexus of this statute, which is the intent to influence the proper administration of any matter within the jurisdiction of the United States, it is implausible that Congress would have passed sub silentio an all-encompassing obstruction statute buried within the altering documents provision of the Sarbanes-Oxley Act. A strong textual indicator that Section 1519 is confined to record-related offenses is the inclusion of the unique term makes false entry in, which Congress only uses in record-related statutes. 1519, first of all, the words record, document, and tangible object, our definition is providing meaning to all of them. The government is saying, admittedly, record and document didn't need to be there, and Congress had no reason to put them there because it's everything. It's all physical evidence. A tangible object is a discrete device. It is a device that is designed to preserve the information.
Well, if that is the case, then why is it not surplusage? What would be a tangible object designed to contain information that would not fall into the category of record or document?
An iPad, a laptop computer, a desktop computer, an iPhone.
Those things in themselves don't. They have documents. They have something that could be called a document or a record stored in them. So if you have an iPad that's straight from the store, has no information stored in that, do you think that would fall within the statute?
It would fall within the statute because what Congress was trying to intend to do, and given the backdrop of the Enron situation where massive servers were destroyed or deleted or otherwise, they were trying to capture the devices that held information. And you cannot determine what's on the device unless you have the device, regardless of whether or not there's information on it or not.